on the subject is a very important part. Very warm good evening to all. Today we are going to dwell on topic which is commonly known as Panchnama. This is a Hindi word and derived from the word panch, which is a Sanskrit word. Panch means five. We as Indians we all know panch means five. And when we say पंचों के सामने बात होगी, this was before the British era. Before the British came, we also had our own judicial system, and this justice system was through the panchas. Now, these panch were respected people from the village society, and they used to decide any dispute between two parties. And this was going on, and once the British came, they came up with this court system. But there are some basic things which remained in our, I would say, justice system culture. Now, when this Panchanama word comes, here it is not five people, it is only two people, Panchanama. I have come across a case in my career where there were three Panchas, but there may be a reason for that. That is a discussion of other things. Today we will discuss what is Panchanama and why it is required and where it is actually filed and who creates or who makes the Panchanama. Now, Panchanama is always made by the police officer, that is investigation officer. Now, in Panchanama, he brings two independent people, that is two independent witnesses. It should actually it is a rule that Pancha should be very independent person, not related to any crime, not related to the individual who's either the complainant or the accused side or the plaintiff defendant. Now, Panchanama is in civil also and in criminal also. But here mostly I will focus on the criminal side Panchanamas. And there are many. And this thing you will never find in any books. Because Panchanama is something, it is like going on like in a culture way. It's a custom. Now, this custom, when we speak, any charge sheet you find, you will find the word Panchanama there. Now, Panchanama will be a statement of two witnesses, independent witnesses. They will be speaking about the crime scene or either seizure, either arrest or something like that, which is connected to the scene of offense. On civil matters, it may be because in sometime taxation matter, there is a raid in the factory, there is a possibility some stocks are taken into custody from any company. That time also Panchanama is drawn. Now, when we speak about the Panchanama, there are many types of Panchanama. Mainly it is 4-5 Panchanama, but I will be having maybe about 10 Panchanamas today. Now, first one is a spot Panchanama. The word meaning spot is a place of offense, place of crime, or place of anything which has happened. Now, spot Panchanama, what is spot Panchanama? At a spot, there may be a body found, there may be an accident taken place. Anything happen at the place of the spot, anything, any related incident. Now, that is spot Panchanama. The police will call two people, independent people who are nearby, and normally in their presence, they will record the what is, it is east, west, how is the road, if it is open place, if it is like a closed place like this room, then they'll find out what was there. There was a table, there was a TV, there was a fan. They will write east, west, everything they will write. The spot Panchanama. Then the next is we can go to the memorandum Panchanama. Now, memorandum Panchanama, you have to be very, very careful. Memorandum Panchanama is something which can actually, you can get acquittal for your client, and also sometimes it may lead to the conviction of the client also. So it is very important. The memorandum Panchanama is mostly the accused is before the police officers and the two panchas, where he says, I have committed a crime with this Rampuri Chaku or any weapon, he may say. Also possible that when memorandum Panchanama is there, there may be some clothes, there may be something he has used during the crime, or he has taken that things at somewhere place, other place also, and he shows that it is kept there. So his memorandum Panchanama is also very important. And if you see any murder trial or any trial, it is very important that when weapon is recovered, it is always through the memorandum Panchanama. Now, seizure Panchanama. Seizure Panchanama is actually very easy. The police comes and seize the things. Now, when you say things are seized, now it may be now in one of my matter, the police went to the Tripura and they seized the laptop, they seized the mobile, they seized the other documents at the home. It may be any certificate, any document. They are going to the place and they seize. Here also the same procedure. Two independent people, they will call from the outside. It may be neighbor also sometime, because if they don't find, and the police has got unfettered power, because for collecting evidence they need to have two independent people. In such kind of things, they will find out people, and these two independent has to sign, and even the IO will sign. Always remember this. Panchanama will be signed by two independent witnesses, which are who are panchas, and also the IO. Now next, inquest Panchanama. Now inquest is about the dead bodies Panchanama. Now sometime when there is a death, maybe because of suicide, because of some accident, or maybe some other crime, maybe murder. Now in such kind of things, when a police takes away the body, while taking away the body, it takes the some how the body was lying there, in what condition, anything related, what is found near the body, how the body was lying down, how it was in such a condition, that things are there in inquest Panchanama. So inquest Panchanama, sometimes the magistrate or the trial judge will tell you to admit. inquest Panchanama है, body का Panchanama है, इसमें आपको क्या बोलना है, क्योंकि body बोलती ही नहीं है कुछ भी. But you have to read that Panchanama. Don't ever, I will say, admit any Panchanama, because when you become a trial court lawyer, normally sometime the judge says spot Panchanama में कुछ भी नहीं है. Also in the memorandum Panchanama मध्ये पण काही असं काही सापडलं नाही वगैरे. Don't do that, please. Always see that, because sometimes they say open place से तो चाकू रिकवर किया है, इसमें क्या बड़ी बात है. Never do that. Read the Panchanama 5 times, 10 times. Ask some senior, then only admit it. Spot Panchanama mein bhi you have to find out where there were blood spots on the road if it is an accident case. If there are blood spots, what is they have taken. Because बहुत बार if you in Maharashtra they write तिथे कसलेही तिथे रक्ताचे दाग दिसून आले रोडवर accident case में. So you have to be careful in such kind of matters. Of course, the blood matching and all things will be required, but you have to be very careful when you admit, because it is a corroborative evidence. It is not substantive piece of evidence, but corroborative evidence is also sometimes can take your client to the conviction. Now, arrest Panchanama, as the name itself depicts, it's a arrest Panchanama. Whenever the police arrest any person, they have to inform the relative, mother, father, or near relatives. If they are not available, then at least the friends. It is whenever your client is arrested, it is very important. Arrest. You can always arrest Panchanama. Kiya kya aapne? Have you done the arrest Panchanama? It is very important part. And there are Supreme Court guidelines also about arrest Panchanama. Now next we go to the IP parade Panchanama. IP parade, identification parade Panchanama. Now identification parade Panchanama is sometime when 3-4 accused are arrested and the complainant, the Firyadi, the person, has not properly seen the, or maybe he is not recognizing. If there is a thief, he may not recognize. The body cases, the people will be new. He's not neighbor, something he knew. So in those cases, there will be IP parade. Now in IP parade also, the Panchanama is very important piece of evidence. Read it very carefully. If it is 4 people, they will keep 16 people. And there are so many rules, so many guidelines about in Supreme Court also. There are judgments that these many people are there. The similar structure people are placed. If I am like this, same structure people. If I am fair, other people also should be fair. So the accused also gets I will say from his side, he has a fair opportunity to for his own case. So it is very important. Read the IP Panchanama, the identification parade Panchanama. It's a very important part of charge sheet, mostly in dacoity case and debt cases. Another is anti-corruption. Also, there are Panchanamas, but there are two. Now is pre-trap and post-trap. You know, all know there is trap in anti-corruption. Pre-trap, they have to take the first two people before going for trap. And after trap is over, again they have to take two people. That trap is over, and these things are found. So it is not either Caesar Panchanama also. It is like Caesar Panchanama, but pre-trap because they are going without informing the. Of course, in anti-corruption they will not inform. So it will be pre-trap Panchanama and post-trap Panchanama. Another is very rare kind of Panchanama, forest Panchanama. I have come across a judgment in forest when there is a Panchanama because of some reason. And this may be because a lot of people are, there are no people available in the forest regularly. Forest Panchanama has to be admitted the way it is made. The forest Panchanama, there will not be much of the, I would say, cross exams on that part because from the forest you can't get the people. The forest Panchanama once done, it has to be admitted. So it is the most, I would say, difficult part to find out anything in the forest Panchanama which will help your client. Mostly it is related to jungle areas where some cruelty is done to the animals. Now, another or last is search Panchanama. Now, in search Panchanama, it is like police comes to your place and they find out, it may be shop also, it may be factory also. They have a search warrant and they may try to find out what is there because they get a tip from somebody that there is something lying in your home, shop, if you are keeping anything. It may be also cosmetic also sometime. It may be also some food adulterated. It may be ghee, it may be shops and all these things. So this kind of here they take the stocks. That's why it is called also stock Panchanama also. The stock is taken. So these were all Panchanamas for today. And yeah, as you go on reading, you will find so many Panchanamas. So Panchanama is a part of every criminal trial. In civil proceedings, like in tax also, there are Panchanama. In civil matters also, there are Panchanama of the place. So you have to be very careful. It may be civil, criminal, taxation. While reading Panchanama, find out if you find any clue which is related to the crime, scene of offense, crime, something. I have come across a Panchanama where the offense has taken place afterwards as per the Panchanama, because if you read the FIR, at FIR it was 7 p.m. and the Panchanama was morning 7 a.m. So these are the things you can bring to the notice of the judicial officer, the judge, and it may help you to find out actually the truth. So Panchanama is something which is very crucial part also, but always remember it is a corroborative evidence, not a substantive piece of evidence. So with corroboration, client may get acquittal also and conviction also. Now here we go ahead with the reading with Krishna. Krishna, read slowly, aram se. All are colleagues only. Just.
Yes. Am I audible?
Audio, you are audible. Just a minute. Krishna
Oh,
is going to read a judgment which is 100 years old, 1920, from the Calcutta High Court.
Srimati Rani Hemanta Kumari Devi versus Maharaja Jagdindranath Roy Bahadur on 8 January 1920. So the judgment goes like the question on this appeal is whether the appellants, the plaintiffs in the suit, are entitled as the zamindars of Pukuria to Malikana in respect of certain temporarily settled estates held by the defendant respondent as accretions to his taluk known as Palasuti Digar. The taluk was carved out of the zamindari before the permanent settlement, and the relations of the one to the other has been the subject of long litigation extending over a century, and only recently terminated by a decision of the Privy Council adverse to the plaintiffs. Hemanta Kumari Devi versus Jagdendra Nath Roy, in a previous case, which also went before the Privy Council, the plaintiffs had sued unsuccessfully for the enhancement of the rent of the taluk. Hemanta Kumari Devi versus Jagdendra Nath Roy. Um, it is now finally settled that the taluk is independent of the zamindari, and the separation effected by the Board of Revenue in 1909 in accordance with the decree of 1805 of the Sadar Diwani Adalat stands ratified. During this period from 1805 to 1809, the land specified, sorry,
You continue, you continue. Somebody's mic is on. You continue.
okay. During
Co-host,
this
please
period,
check that.
sorry ma'am,
You continue. Co-host will check whose mic is on.
yeah. During
Just a minute, Krishna. Unmute yourself. Krishna, unmute yourself.
Yeah, sorry ma'am.
Yes, yes. Hmm.
So during this period from 1805 to 1909, the land specified in the two schedules attached to the plaintiff emerged as the chars from the river Brahmaputra and Jamuna. The lands in the first schedule between 1834 and 1842, and those in the second schedule in 1881. Government resumed their chars under Regulation 2 of 1819 as accretions to the taluk, and subsequently formed them into separate khas mahals or estates with separate tauji numbers. The estates so formed were temporarily settled from time to time, for the most part with talukdar from for the time being. The prior right of zamindars to settlement was recognized, but they generally refused to take it on the condition on which it was offered to them, namely that they should not disturb the possession of the talukdar. On the one hand, therefore, the lands have been uniformly treated as accretions to the taluk. On the other hand, when settlements were made with the talukdar or third parties, the proprietors of Pukhuria were always allowed malikana calculated at the rate of 10% on the assets after certain deductions had been made. On the one or two occasions when the estates or some of them were settled with the latter, they merely became the channel through which the revenue was paid to government, and nothing in the shape of profits went into their pockets except a sum equivalent to the malikana which they would otherwise have received. The amount allowed for expenses of collections as well as the 10% for talukdari profit went to the talukdar as being in possession. This appears for the instance from paragraph 22 of Collectorate Rukkari of 21st century 1874, and from the final report regarding the resettlement of estate number 8549 dated 19th July 1904. When a fresh settlement of estates was being made, the Board of Revenue decided in 1910 that in the consequences of the separation of taluk and its independent status, the plaintiffs as zamindars of Pukuria were no longer entitled to malikana, the estates appertaining not to the zamindari but to the taluk. The present suit was brought in 1911 as a declaratory suit to contest this decision. The quinquennial register of 1795, prepared under the regulation XL 8 of 1793, shows in the column headed Moza and Kismat, the only column provided for the purpose, the assets of the Pukuria estate or Pargana Pukuria, on which the fixed revenue Mokra Jama was assessed. The entries consist mostly of mozas, properly so called, that is village areas. Two entries occur, however, Jal Hatua or and Jal Jamuna, which prima facie denote fishing rights in areas described as Hatua and Jamuna. The lands in dispute have formed in a part of these areas ever the whole of which water flowed at the time and at the time of permanent settlement. The plaintiffs contend on the strength of the word Madza in the heading that was permanently settled with their predecessor comprised not only such a word in the heading of a column in a register. In the state of things suggested, the talukdar would have had no right to the land as accretions to the taluk, and the zamindar would have been entitled to hold them as the part of his zamindari without paying any additional revenue. No such claim was ever made when the lands first emerged. It may, however, be fair to add that after the changes in the land levels produced by the earthquake in 1897, some litigation occurred concerning Jal Hatua as a fishery, and that each side has found it advantageous to adopt what was then the argument of the other side. The judgment of District Judge Maimen Singh dated 20th April 1903. The exigencies of self-interest sometimes demand such change of fronts, but it is useless to pursue the subject further because of the right of the government to assess the lands to revenue is not now challenged, and the plaintiffs admitted before us that they must long ago have lost by lapse of time and law of limitation any rights which they might originally have claimed on the footing of their present contention, either as against the government or against the defendant, save and except the right of Malikana. The contention was apparently put forward not for any direct advantage which it might bring, but as an excuse for not very meritorious case which they finally made. Nothing turns on the action of the government in forming the lands in dispute into separate estates. All the lands were resumed have been held as the accretions of the Taluka Act 31 of 1858 merely regularized a practice which had previously been in vogue. This is shown by documents exhibited in the suit and by preamble of the act itself. No doubt, Section 1 of Act lays down that when alluvial land is assessed and settled as a separate estate with a separate jama, it shall then thenceforward be regarded and treated as in all respects separate from and independent of the original estate. For example, if the new estate falls into arrears of revenue, the government may sell it apart from the parent estate. So here it may be doubted whether the separation of taluk from the zamindari is in itself effected a similar separation of the resumed estates. But the title to the latter, now that the separation of the taluk is an accomplished fact, is another matter. The Act of 1855 has no bearing on the question which arises whether the plaintiffs still have any shred of, proprietary right in these estate which would entitle them at a new settlement to Malikana. We must look to the origin of estates, the mode in which they have been held and enjoyed, and legal effect of the decree of 1805 and the state of things which followed it. The provision of regulation 11 of 1825 have also to be kept in view, that the estates must now be regarded as accretions to the taluk is indeed assumed and conceded in the argument to which the plaintiffs were driven. It is said that taluk having been declared independent by the decree of 1805, the plaintiffs had no legal right to maligana from the time when the defendant acquired by adverse possession or otherwise a proprietary right to the estates as accretion to his taluk. The state of things in which the plaintiffs were wrongly treated as proprietors and malikana was wrongly paid to them continued for more than 12 years, and they, on their part, have thus acquired by adverse possession a proprietary interest in these estates, extending to the right to receive malikana in respect of them.
Okay, okay, Krishna, wait, wait. Thank you so much. Very well read.
Yes, ma'am.
Okay, you can mute yourself now. We'll go to legal vocabulary. Visible है, हैंड्स अप कर दो, समझ में आ जाए. ओके, थैंक यू, थैंक यू, थैंक यू सो मच. The first word is dubious. Now, not sure or certain. Now, the how do we use it? The findings of the this is finding dubious. These are all legal. I won't say legal, but these are mainly used in the legal terms. The findings of the inquiry officer are not only that the petitioner was reckless, but also his conduct in a large number of transactions was dubious, doubtful. Perus. To read something especially in a careful way. We जब भी सबमिशन करते हैं, my lord may peruse the charge sheet, my lordship may peruse the statement of the complainant. The magistrate shall then peruse the statements so put in, here the parties receive all such evidence. Reprehensible. Behavior that is deeply immoral, galat, unacceptable, condemned mostly. This reprehensible conduct of the accused qualifies as a criminal contempt under section so and so of Contempt Act. Veracious. The Hindi word is very perfect. Satyapre, sach bolne wala. Speaking or representing the truth. He does not appear to be convincing, truthful, and veracious witness. See, where the word is used, veracious witness, and his testimony suffers from various inconsistencies. There's so many words which are regularly used in legal document are there. Pretense, an action that makes people believe something that is not true. Pretense, pretend भी करते हैं ना वैसे. That the allegation in para number 2 of the plaint is only a pretense and total fabrication put forward with a view to create jurisdiction. गलत बताया गया ताकि jurisdiction बन जाए. Concede, कबूल करना, मतलब हिंदी में perfect word है. Admit. It is a further noteworthy. Despite the twist on this point given in examination chief, Rataseva had to concede under the stress of cross-examination that at the time of the said dispute, Kima was also present in the compound. Concede. So, accept क्या admit क्या नहीं बोलते. The good word is concede. Considered, कबूल किया. Inquest Panchnama, we just now saw it. An official process that tries to find out how somebody died. Mostly लेकिन body का ही पंचनामा होता है. It is impossible to find out how because there is a postmortem always, and police is not somebody who is expert in postmortem. But inquest panchanama is done by the police, postmortem is done by the doctor. Exhibit 12 is the inquest panchanama in respect of dead body of Mr. So and so. Capitulate. Capture बोलते हैं वैसे capitulate. Pronunciation. Surrender. Those two persons exerted threat and pressure on them to capitulate to their demand. इतना pressure डाला कि वो डिमांड को मान गए, सरेंडर कर ले. Apprehend, mostly anticipatory bail में यूज होता है. To catch somebody and arrest before considering the claim of the appellant, it is useful to refer section 438 of the code of, ये पुराना section है 438 CRPC का, relating to the grant of bail to a person who is apprehending arrest, which is read as under. Unscrupulous. Now, dishonest. This word is rarely used, but you will always find in judgment. You can use this in 130 check cases, or somewhere forgery is done, cheating is done. I found out somebody in 130. The introduction of this said chapter was intended to create an atmosphere of faith. See, atmosphere, how we use, how it is used. Atmosphere of faith and reliance on banking system by discouraging people from not honoring their commitment by way of payment through checks. Section 138 of the Act was enacted to punish those unscrupulous persons who purported, see again new word, to discharge their liability by issuing checks without really intending to do so. So those who does not know, interns here, section 138 relates to the check bouncing cases. So this was all today. Good words. Vishaka, Lalita, thank you so much. Now, next is maintaining the decorum of the court. I'm very happy that I'm speaking on this subject first time. About 2 days ago, I recorded a short video on this about maintaining decorum of the court. I was in the Supreme Court for some conference on the Sunday, and from there I had attended some proceedings before the Supreme Court of India. There I was sitting. How this subject came to, I would like to tell you by way of incident. Now here, a lawyer who was fairly having a standing of 10 years coming to the court, Supreme Court, and saying my this matter, this was done, I was not there in the morning. First thing, that is also not a proper etiquette for the court, not maintaining decorum of the court. Now here he was telling that my I was there was technical glitch, I couldn't online, I couldn't appear, that's why I've come now. The honorable justice from the Supreme Court accommodated him, and this was his last matter. The judge was about to rise means वो जाने वाले होते हैं, and that time there, because there are two judges, there are two people, maybe peon or somebody who takes them back to the chamber. They were coming. Now this is unwritten rule, my senior has taught me, and I want to share it with all of you. It is a, see here also, when school principal comes, do we stand or not? Even in left, if there is an elderly person come, a lady come, we give the way to them. The court is also is a temple of justice. When there is a judge, see, we are not respecting the judge, we are respecting the court premises, the seat of the judge. She may be younger to you, then also you have to respect the that seat of the court. Now the judge was about to write, this person comes, mention his matter, and goes. I saw along with me 4 5 lawyers were there, because it was 4 o'clock in the evening at Supreme Court. Now these people, uh, we all were standing because we knew the judge is now there. He or she is going to rise. Now what I saw, this man goes away, and we are all standing. And after the court was over, I tried to find him out, just to tell him that this is not the right way. But I couldn't find him. But I thought I will make a at least short video on the maintaining decorum of the court. See, court is a place where we have to give the respect to the judge, because they are imparting justice. Just imagine a system without court. Something happens, first thing you remember police, and second thing you remember court. And now when you do not respect that place, what will happen? This is not the right way to do it. Court is a place you can't leave. I have been told, when there are no people in the court, and you are mentioning the matter, or your matter is last one, and court is about to end, maybe lunchtime, maybe in the evening. Mostly these things happen 2 times, when the court is about to rise in the evening, when the court timings are over, or before the lunch break. You have to wait till the judge rises and let the judge go, then you come out of the court. Because मुझे सिखाया गया है कि कोर्ट को अकेले नहीं छोड़ा जाता, डेकोरम मेंटेन किया जाता है. So you have to maintain the decorum of the court. You can't leave the judge, or let me say, you can't leave the court like that. वहां 4 लोग होने चाहिए. That is called maintaining the decorum of the court. So you have to wait till the judge rises, then you leave the court. But there is an emergency. There may be something which you need to go to another court, maybe family emergency. Then in us time pe bhi I am taught, ask the court, may I take the leave of the court? May I take the leave of the court? एक line बोलनी है, and 100% the judge allows you. Yes, yes, you may leave. Yes, yes, you may leave. Because sometime in trial court, I have seen the judge discusses some matters with the staff sitting there only after the matter is over in the evening. That time you can't sit. I understand. You have to go to some other court, you have to attend your office. But then also you have to say, can I take the leave of the court? Or leave before the court rises when there are many people and nobody can see you. This is very, I'm sorry. It's important, I would say, important ethics, court ethics, I would say. Everybody should know, never leave the court alone. And if you are leaving the court alone, only with four people, take permission. Don't leave the court without permission. There is a video I have made. I will be sharing it again in all the three groups. This is the basic. If you take this one thing from me today, I'm very happy for this today's lecture. I think 200 people must are attending. So if you know this much, this is more than enough. There are other ethics also. You can't shout at the court. Don't shout. About this also, my seniors has taught me that if you shout at the court is not going to see. If you shout at somebody, you know you will be accountable for date. No, you are making judge angry. You're आप पूरा atmosphere खराब कर रहे हो. You're ruining the atmosphere of the court. Also, sometimes you are shouting at the court. You're not making point. Court is asking something else and you're answering something else. Sometimes you're not in a proper uniform. That is a maintain decor. You can't wear red, blue, and go to the court. There is a in bar council rule. There are cloth color, light color coat. For ladies also there is, but I will prefer black and white. That is the uniformly proper uniform for everybody. Black and white would be proper. But there may be, and you should wear the black coat. You should, in the high court, it is gown. So it is properly. If you are wearing a tie, it should be proper. It should be neat and tidy. Iron किया हुआ, press किया हुआ. Court is not place अपना गरीबी का प्रदर्शन करो. That doesn't mean कि you should be showing your richness also. No, not required. But decent. I would say, decent dressing होना चाहिए. Secondly, punctuality. That is one thing. Sometime I saw one lawyer coming. Uh, I did not get the train. I'm late. I got the traffic. Traffic. कुछ नया कारण बताओ ना. ट्रैफिक रोज का है. कुछ नया कारण बताओ ना. There's emergency बताओ. Every day you're late. No. Because court also knows. And I've seen if you're sitting before the judge comes, and when they come, they bow like this, and we are also there. So we know the judge also sees you that yes, she has come. She cares for her case. She's there. And also because other lawyers are there, they are mentioning the case or their matters are called out. So you know how it is so important. Now Smita is writing, Bo is very important. It's very important when you go to the court. Now let me tell you, I had been to Allahabad High Court. There must be somebody from Allahabad. Now इलाहाबाद हाईकोर्ट में आज भी जब जाते हो सीनियर के पैर छूते हैं. मैं आज भी करती हूँ. अंधेरी कोर्ट से बख्शी मैडम है, नायक सर है, और सुप्रीम कोर्ट में आशा नायर मैडम है. टुडे ऑल्सो आई मीट देम वेर एवर दे आर. मैं एक बार उनका चरण स्पर्श कर लेती हूँ. दे आर माई गुरु. मुझे सिखाया उन्होंने. वॉट एवर आई हैव लर्न फ्रॉम देम. एंड देर आर अदर पीपल ऑल्सो. आई डू ट्राई टू दैट. हम लोग चरण सुने. इलाहाबाद में वो सिस्टम है, कस्टम है. आई एम सो हैप्पी. आई वॉज वेरी हैप्पी कि कितना अच्छा कस्टम है. जरूरी तो नहीं हाय हाय करो. कोई अगर एज में बड़े हैं, टेक ब्लेसिंग. एंड लेट मी टेल यू, दे विल शेयर देयर ब्लेसिंग्स इन द फॉर्म ऑफ, बोलते हैं कोर्ट क्राफ्ट बताएंगे, या फिर दे विल टेल यू समथिंग. आई हैड गॉन टू ऑल्सो ग्वालियर हाई कोर्ट. आई आस्क्ड देम, वन सीनियर, this he was designated senior and he was about 75 years old. I believe what sir we should do. उन्होंने दो तीन चीज बोली. उसमें सबसे इम्पोर्टेंट था रीडिंग ऑफ द जजमेंट्स, डिसेंट वेयरिंग एंड पंक्चुअलिटी. एंड वी ऑल नो हियर these all things are important in any profession. So main thing you should do is the dress code. For you know what should be the dress code. See, if you are going to the court, it should be black and white. It's good. When I intern comes to me in the beginning, I keep quiet. But after, if they are going to the court, I tell them be in the uniform. Today, I think I told Krishna also. he will concede to that please मतलब आप यूनिफॉर्म में रहना, बिकॉज स्पीकर ऑफ दी, आप स्पीकर हो, 200 लोगों के सामने बात करनी है, अब जब टी शर्ट पहन के नहीं खड़े हो सकते. दिस वीडियो आई मे डिलीट ऑल्सो, बट नो, if it is not deleted also, there are 200 people watching you, so be careful. So ये etiquettes of the court है, maintain the decorum of court. हम मंदिर जाते हैं ना, we go to temple, right? We don't go बिना नहाए या फिर ऐसे ही नहीं चले जाते कुछ भी कपड़े पहन के. I have recently I have been to Jogeshwari Rameshwar temple. There is dress code written. ये पहन के आना है. I had gone to few Ashtavinayak. There also dress code is written. There are reasons for that. People are wearing and then going to the temple. So this is also court. Court is not different. It's a temple of justice. मेरे लिए तो रोजी रोटी की जगह है, आपके लिए भी है. आपका फेम, आपका मनी, आपका करियर, आपका रेपुटेशन, एवरीथिंग इज कमिंग फ्रॉम कोर्ट. Then why not dress up properly and go? And when you dress up properly, judges are also impressed. It's not that they can see everything, but it can be seen. In Bombay High Court, I have seen एक यंग लड़के को प्रॉपर ड्रेस कोड नहीं, उन्होंने सिरस्तार को बोला प्लीज आस्क हिम टू ड्रेस प्रॉपर्ली देन कम. हो गई छुट्टी कोर्ट के सबके सामने. What was the need? You're appearing in the high court, you're not in a proper uniform. Don't do that. It is very important. I was in Supreme Court, one judge who was retiring who said, I want to admit today that I have given good orders. So little bit I would say I was a little bit favoring them, those juniors who were in proper uniform. ये क्या बताता है ये चीज अपने को? What is it pointing out to us? That the court also likes you when you are in proper uniform, in court properly. As a woman, when I see somebody in a proper white sari, I feel happy and I compliment. So as a man, as a young man, woman, also you should be dressed properly. And decorum, I have told you, that is a very important part. Never leave the court alone. That is very good thing. So this was all for today. Thank you so much for attending such a huge number. Thank you so much. I hope it adds value to your knowledge and also the profession. Anybody has question, one by one we can take. You can unmute yourself and tell.
Hello.
Yes.
Good evening, ma'am.
Good evening, Reddy sir.
How are you, ma'am?
I'm good. I'm good.
So I'm very happy to share a few words regarding the sessions which I attended here. So it was so helpful, madam. Really, I'm enjoying to watch your videos repeatedly and also getting a good judgments. So I'm very fortunate to see you and also learning from you a lot, madam. Because now I'm very confident to become a good lawyer because I'm in the field.
That is what I want. That is what I want.
So
I always, see, Mr. Reddy, I always tell, हमें कैसा डॉक्टर चाहिए? We want a doctor who is very expert. How? What kind of lawyer we should? We also should be expert and good and honest. We want honest doctor, right? Or everybody of every one of us. Then we should be also honest lawyer, right? Simple.
Yes. Yes, ma'am.
Thank you.
So thank you so much, ma'am.
Thank you, Reddy.
Thank you, ma'am. Ma'am, good evening. I'm Savita here.
Yes,
So
Savita.
this is the first time I am listening to you, and thank you so much for your information. I just wanted to ask certain things like you have chosen the very good topics, ma'am. Very interesting. By looking at the topics, I thought of joining the meeting, whatever may be the work I am right now doing. And I would like to ask, like the judgment you read, and whenever we read the judgment, because I am just completed my LLB and I am doing my practice. I mean, totally initial stage, I can say.
Okay.
So, what I wanted to know is how to read these judgments and I mean, how to make points, certain points so for the beginners because it is very confusing. So many things are there. So many.
I got you.
Yes,
I'll tell you
ma'am.
something. See,
If
there
you,
is nothing like confusion.
yes,
Suppose, see, you have just begun, what I have understood. Those
yes,
who have begun, I will tell you, you start reading randomly. First, one day civil case, one day family matter, one day arbitration. Start reading anything. I normally use Indian Canon since I think
okay,
about maybe more than 15 years now. I don't
okay,
know how long I've been using, but I'm very fond of IndianCanon.com. I use that.
okay,
Now, you start reading any judgment, one day civil, one day criminal, one day arbitration, one day consumer. And what you can do, if you get an accident case, start reading all accident cases
okay,
related to that. If you don't have cases, read anything.
okay.
Anything law, anything related to law, but read differently. One day civil, one day criminal, one day family, one day arbitration, one day consumer, one day tax. Read everything. That
Okay.
will help you to improve your English, legal acumen, also the legal vocabulary.
Thank you so much, ma'am.
Thank you.
Thank you.
Thank you, Savita.
Thank you so much, ma'am. I'm Kamal from Ghaziabad.
Thank you, Kokomal, attending. I'm so happy. I come
Nice.
to Ghaziabad often. Vandana madam is there. She's also AOR, my friend. And there are some
Okay.
videos on my channel about her also. She's very good.
Okay.
And I keep coming to Ghaziabad. So I know what is Ghaziabad.
Okay. Thank you so much. Nice to meet you and nice information for this type information from legal. And actually, I want to learn more than more. So it is very important for me. Thanks so much, ma'am.
Thank you. Thank you so much. Okay, I'll wind up for